This is the place to be.
So with that, we're gonna start the workshop portion of our meeting from 7 until 7:30, at which point we will switch over to the regular agenda. So with that, we thought it would be good to talk a little bit about Planning Board 101 and Seqr 101.
Yeah.
A little bit of a recast of, especially with Seqr, some of the things that we've reviewed in the past, but always worth a refresh.
Yeah, absolutely. Yeah, so apologies if you've seen this presentation before, because I have done it. It's been a couple years, but hopefully there'll be a pop quiz at the end.
I think for Seqr, we could do it frequently and still learn something.
Yeah, so we're going to talk a little bit about Seqr Basics, or Seqr 101, but first, I spoke to the chair about starting with sort of a civics 101, just to kind of reorient and discuss, what our role of what the role of the planning board is in relation to the city council and the zoning board, and how they all interact together. So I think that's always a good place to start with as a refresher, not just for the board, but also members of the public who are listening too. So
Fantastic.
We'll talk about the source of the planning board's authority and its role in relation to zoning laws and other boards in the city. So first, the city council. That's where it all starts. So the city council is obviously the legislative body comprised of elected officials. They adopt your local laws, adopt your code, and set the policy for the city. So an example of this is the comprehensive plan that's adopted by the city council sets the policy, sets the vision for the city, with input from the public, obviously. And then zoning laws are adopted consistent with the vision in the comprehensive plan. And that's all done by the city council, by your elected officials. Then we have the zoning board. The zoning board is a board that is required by state law. Every municipality has to have a zoning board. And it's empowered by state law to grant use variances and area variances. I know we're all familiar with the differences between the two variances. They do both have separate and distinct standards of review that the zoning board has to follow, and where the applicant meets those standards as judged by the zoning board has the power to vary or modify the zoning code as it relates to that applicant. So it's sort of the relief valve. Because we have a zoning code, we have to have a zoning board to provide relief for particular and unique circumstances. Because zoning is it's never a one-size-fits-all endeavor. There's always going to be exceptions or modifications that need to be made for particular circumstances. The other thing the zoning board does is it hears appeals of building inspector determinations. So if the building inspector interprets a provision of the zoning code a certain way, and the property owner feels aggrieved by that particular determination, thinks the building inspector got it wrong, they can appeal that to the zoning board, and the zoning board acts as the appellate authority for review of interpretations of the zoning code. And then we have the planning board. So the planning board is an administrative board that's actually not required by state law. Not every municipality has a planning board. In some municipalities, the legislative body retains that land use authority. So the planning board's authority is really limited to that which the city council, your legislative body, delegates to the planning board, as set forth in the zoning code. And you'll see you've got various pieces of authority in the code for site plan and subdivision, and now a lot more special permits than you ever used to. The city council in the past had retained that authority to themselves instead of delegating it to you. Over the past couple of years, they've acted to give you more of that authority over special permits. In fact, it might be all special permits now at this point, I think. The planning board reviews each of those types of applications that have been delegated to it within the confines of the standards that are set forth in the zoning code, again, that are legislated by the city council. So here, as you know, you have site plan authority, subdivision authority, you have special use permit authority, as we mentioned, and you also act as the architectural review board. So you guys wear a lot of hats when it comes to land use in the city of Beacon. In applying the standards that are set forth in the code, you do have a good deal of discretion in interpreting what they mean and applying those to each application. But that discretion is not completely unfettered. We do have to recognize that those standards are adopted it's sort of with a balance. You got to strike a balance between an applicant's constitutional property rights, right, and the legitimate controls that are put in place through zoning to protect the community, to protect what's called the public health, safety, and welfare of the community. So you're always trying to strike that balance between those sometimes competing interests, right? Most times competing interests. Now, before I move on to Seqr, I just want to touch upon sort of your overarching standard of review. I think this is always important to kind of go back to and remember that every single decision made by the planning board, made by the zoning board, has to have a rational basis in the record. That means there has to be support in the record for your decision. Otherwise, a court might find your decision to be quote-unquote arbitrary and capricious. The record is everything that's before you. It's the application materials, it's testimony from the public, memos from John Russo and Natalie. It's meeting notes,
video.
Absolutely. Yep. It's everything that has been presented to you for you to make your decision. You really should not be and cannot be relying upon like a gut feeling or personal opinion when judging applications. We can't, as a planning board, just deny an application because you personally don't like it or there's a groundswell of public opposition against it. It's not a popularity meter. We have very specific standards that we need to go by. And I know you all know this, and we're just doing this as a refresher. It is, yeah. It's just good to kind of level set and remember that. So again, kind of overarching, city council sets the standards, and you determine whether an application meets those standards. So that's our quick civics lesson for the day. And now with the time remaining, I'll go through some Seqr basics.
Just real quick though, any questions?
Any questions about that?
No? Pretty clear?
No? Okay, good. All right, so I do have slides. Whoops, how do I? Why is it not?
Quick, what does Seqr
advancing?
stand for?
There we go.
State Environmental Quality Review.
Gold star to Len.
I had to look at the letters.
Extra credit point. All right, so we'll talk about what is it, why do we use it, and how do we use
I
it.
didn't read it off the screen, but it was there.
Seqr.
I like it with the A.
I know,
Some people leave off the A. Okay, so what is Seqr? Well, in 1975, the New York State Legislature adopted a set of statutes called the Environmental Conservation Law. And then a year later, the Department of Environmental Conservation adopted a set of regulations called Seqr. So those regulations are designed to implement what we know as Seqr today. And, yeah.
I'm assuming other states have something very similar.
Yes, so NEPA, the National Environmental Protection Act, that's the national standard, so federal actions go under NEPA.
Mm-hmm.
Most states have what they call little NEPAs.
Some version of NEPA.
Some version of it, yeah. Not all, but.
We had to be
but many.
different and make our own and call it Seqr.
Yes,
California too, was Seqr with a C.
yes. Yeah, and
What's
actually the city, New York City has its own version of it as well. So the purpose is to assess environmental effects of discretionary actions, so not, checking boxes, issuance of a building permit, checking boxes and issuing a permit, but discretionary actions that can be reviewed and approved or denied at your discretion based on standards. When applied as it's intended, Seqr is really meant to be a tool for infusing environmental considerations into the decision-making process so that we can create better and more sustainable, less impactful projects. So that's the whole point of why we do Seqr. It's not the intent of Seqr that environmental factors, your typical, birds and bunnies and bees and wetlands, that is not supposed to be the sole consideration when we're talking about Seqr. Instead, Seqr requires those factors to be balanced with social and economic considerations as well. So, for example, if you have a project that might result in some wetland buffer or, direct wetland impacts, but it's going to bring a whole host of needed affordable housing to the community or bring, much needed jobs to the community, that's a balancing that is done during Seqr to weigh those various factors. Courts have also said that an agency does not have to investigate every conceivable environmental problem. It may, within reasonable limits, use its discretion in selecting which ones are relevant. And that goes to this overarching theme in Seqr called a rule of reason. It's governed by a rule of reason, is what the courts usually say, in balancing the various considerations and applying the regulations reasonably. So there's two different categories of compliance, procedural and substantive. Procedural compliance is exactly what it sounds like, strict compliance with the procedures that are set forth in the regulations. So an example of that is Seqr requires that projects that are classified as type 1, and we'll go through what type 1 means, require a full environmental impact statement. So the 13-page, not environmental assessment form, the EAF, that full 13-page EAF. You're familiar with the EAFs. They get submitted with every single application, but there's a short form and a long form. Type 1 requires the full. If an applicant does not submit the full for a type 1 action, and that's not caught during the board's review, if that Seqr determination is ultimately challenged, that person challenging it will win. Courts have overturned Seqr determinations where the wrong form was used. So again, that strict compliance is really important. And that's part of what my office does, and Natalie's office, and John's office. We all make sure that those strict procedures are being followed as the board reviews the various applications. So substantive compliance is, the courts will look at whether the board took a quote-unquote hard look. So this is getting to more of the substance of the application and its environmental impacts. So courts will look to see whether the board did a couple of things. One, identified the relevant areas of environmental concern. So, what is the particular issue at hand for that application? Is it wetlands, traffic, steep slopes, stormwater? What are the relevant aspects? Did the board take a hard look at those relevant issues of environmental concern? And a hard look has been defined by the Court of Appeals, the state's highest court, as a thorough investigation of the problems involved. So again, kind of amorphous, not very specific, but it really means it's not a rubber stamp. You really have to analyze how a project is proposing to address the impact that's been identified, either through avoidance or minimization or mitigation measures. And then the last thing the court's going to look at is whether the board, when it made its Seqr determination, so if you issue a negative declaration, did you make a reasoned, what's called a quote-unquote reasoned elaboration for your decision? And what that really means is you're going to state for the record why there will be no significant adverse environmental impacts. That's, every time we do a negative declaration and you have before you that multiple page document that goes through each of the impact categories, that is your reasoned elaboration. We're citing to documents that have been put into the record and explaining why you believe that there will be no significant adverse environmental impact. And that all goes to the importance of creating that record. Because if and when a decision is challenged, the court is only going to look at that record. That's the only thing that the court is allowed to look at. So if we don't have support in our record for the decision that's being made, that's going to make you vulnerable to having your decision be overturned.
I have a quick question. if I
Yeah.
may. So you mentioned the steep slopes, which is a beacon law itself. Do we know off the top of our heads what city-specific laws we have? Like, do we have we have drinking water wells, do we have a wellhead protection area?
That
you
would be
know-
under Department of Health, that would automatically come into play.
Okay. Is there anything else that just we ought to, as a board, just have in the back of our minds that are the unique laws to Beacon other than steep slopes?
I mean, you do have a wetlands provision.
And that's pretty,
But ones that are specific to, you have the Fishkill Creek Development District, which has, some particular requirements for that district.
But not a buffer zone specifically.
right, it's not, I'm thinking specifically of environmental stuff. Like we know when there's wetland protection, there's habitat and wildlife, sensitive receptors or species or whatever, but then we have that steep slopes, maybe that's the only one that's.
Yeah, but just because there might not be a code provision on the books,
Yeah, it
let's say,
doesn't- it
for
doesn't
example,
excuse us for it.
wetlands.
I'm just thinking, is there
Under
anything
Seqr,
we
you
should-
still review the impacts to
Yeah, I
that
know.
resource, yeah.
I just wanted to know if there was anything else unique to our code.
Not that I can think of off the top of my head that I don't also see in other communities. Historic preservation is another one. You have a pretty robust
View sheds, did we
Provision.
mention them?
Oh, that's one, yeah.
view sheds,
We
yeah,
have the
you
view
do
sheds.
have view shed protection.
Yep.
In the waterfront plan, right?
The LWRP, the
The
local
LWRP.
waterfront revitalization plan, absolutely. Yeah, yeah, so those are all good,
There's some good
good
stuff there.
examples.
Yeah, but I think it just behooves us to kind of repeat it. and
Yeah.
Yeah.
It's in the mental list that you have to tick through when you're looking at stuff.
So, with the last 10 minutes or so, we're just going to go very quickly through the basic framework of Seqr. So the step-by-step process. Starting when the application is filed, the first thing that we do is we classify the action. Is it type 1, type 2, or unlisted? Type 1 being, and there's literally lists in the Seqr regulations that specify categories of types of applications that will be type 1 and categories of applications that will be type 2. Type 1 are those that DEC has already determined are more likely than not going to require an environmental impact statement or a positive declaration. Not all the time. Just because it's type 1 doesn't necessarily mean that an environmental impact statement is required. It's just more likely than what we'll talk about. It's an unlisted action. Type 2 are those that DEC has categorically determined will not result in significant adverse environmental impacts. So those are exempt from Seqr review altogether. That's construction of a single-family home, more minor applications like that. And then unlisted are literally that. They're not on the type 1 list, they're not on the type 2 list, they're unlisted. So the board, similar to a type 1, makes its determination as to whether there's a significant impact. This step, the classification, is typically done, by your staff and consultants before it even gets to your board for the first time.
Quick example of an unlisted type of application, if you don't mind.
2-lot subdivision, 3-lot most of the subdivisions that you see on your agendas are unlisted.
Yeah. And they remain unlisted. That's simply their category.
Yeah. So, and that's why that step is typically done, by your staff and consultants before it comes to your board, because it's sort of black and white. It is what it is.
Yeah.
There's no discretion involved in classifying the action. The next step is determining who the lead agency is going to be. And you're familiar with this stuff. This is when you authorize circulation of your notice of intent to be lead agency. Lead agency being the board that's going to have responsibility to review the environmental impacts of the project as a whole. there might be any number of boards and agencies at the local, county level, state level, even federal level that have some kind of approval authority over the project, whether it's a New York State DOT highway work permit, a variance from the zoning board, a zone change from the city council. So each of those agencies or boards that have an approval authority are technically eligible to be the lead agency. In most projects, it's the planning board that serves in that role, because you guys have the expertise. Sorry, city council, sorry, zoning board, but you guys typically have the expertise to be the lead agency.
I don't think I've once yet seen anyone, once we declare intent, come back and say, oh, no, I want to be lead agency.
Right, right.
Yeah.
And when there is a fight like that between who wants to be lead agency, it goes up to the DEC commissioner, and the commissioner decides who's going to be
Sounds
lead
like fun.
agency. So when you have a type 1 action, you have to have a lead agency. When you do unlisted actions, you can do what's called an uncoordinated review, where each of those individual agencies does their own environmental review, separate and apart from everybody else. We don't typically recommend that because each agency has to review the whole project, not just what's within their jurisdiction. So it ends up being very duplicative and just not very helpful.
So we usually declare intent to act on both,
As lead agency,
type 1
yeah.
and type 2.
Type 1 and unlisted.
And
right.
unlisted,
Yeah,
sorry,
yeah. So, moving on, so once we have our lead agency, the next step is for the lead agency to determine significance. So are you going to do a neg deck or a pos deck? Is there the potential for a significant adverse environmental impact or not? So the question I always get asked when I do this presentation is like, well, what's significant? How do we know what significant is? And it is a little bit subjective. It's going to change community to community. What's significant in, Yonkers might not be significant in, Clinton County. So it is going to change as far as that threshold is concerned. But typically what you would look at is the magnitude of the project, so the size or the extent of the impact, and the importance of the project, which Seqr has defined to mean how many people are impacted, the geographic scope, and the probability of an impact occurring. This is typically a step that can be time consuming. Technically, under the regulations, you're supposed to make your determination of significance 20 days after you establish lead agency, or what's more often used, 20 days after you've received all the information necessary to make that decision. So there's this one case that I always like to cite too it's from 2005 out of the town of Marlborough. And there, the planning board took 853 days to make their determination of significance. But the court said, that's fine. The court said, in our view, the planning board as lead agency painstakingly undertook to gather substantial data regarding the application, holding public hearings and public meetings and hearings in order to receive and consider evidence from all interested parties. Following the expiration of the deadline for submissions, the planning board issued the negative declaration at its next regularly scheduled meeting. Thus, we conclude the declaration was not untimely. Now, obviously, that's not an ideal situation. You don't want to take that long to issue a neg deck. And we need to remember that, Seqr should not and cannot be used as a weapon or as a delay tactic. Unfortunately, we see that sometimes, typically not here in Beacon, but I have seen that in other communities where Seqr is unfortunately used as this delay tactic, but we
Used for
don't want to.
slow walking, yeah. They use
Yeah.
it for slow walking.
Yeah.
And by the way, I'm sure, I know we all know this, but a negative declaration is a finding of no significant environmental impact.
Correct. Negative declaration ends the Seqr process,
Right.
meaning there's no significant impact. And there's a quote from the Suffolk County Supreme Court from 2008 that I like on this issue of Seqr being used as a weapon. And the court said the purpose of Seqr was never intended to be a weapon indiscriminately used to frustrate legitimate applications by property owners for reasonable development of the property for which they pay taxes. The purpose of Seqr was to require responsible redress of actual environmental concerns in order to mitigate impacts in a rational and productive manner. So that goes to one of the first things we said, that Seqr is a tool to arrive at a better project. The next 3 steps we're going to talk about in the next 4 minutes relate to what happens if the board determines that there may be one or more significant adverse environmental impacts, and you issue a positive declaration. So the next step that's going to happen then is you're going to undertake scoping, which is a mandatory process as of 2019. And a scope is basically the written document that outlines all the issues that are going to be studied in the environmental impact statement. It's really intended to narrow the issues only to those that are relevant and have been determined to be potentially significant. Then, after the scope is finalized, the applicant's going to go on their merry way and prepare the draft environmental impact statement. And that's the voluminous document. Sometimes in the old days, you'll see binders and binders full of these documents. Now they're, a lot of megabytes, I guess, electronically. But it examines the nature and extent of all potentially significant adverse environmental impacts, as well as alternatives. And that's one of the keystone features of an environmental impact statement, is the analysis of alternatives. So the applicant is required to study not just their proposed project, but a number of reasonable alternatives that are feasible for the applicant and meets their objectives. So typically you'll see like a lesser density alternative, or an alternative of a building with a lesser height, a different layout of the proposed building. So there'll be a number of alternatives studied. Then, after the DEIS is prepared and accepted by the lead agency is complete, there's a public hearing. Then the applicant prepares the final environmental impact statement that responds to literally every substantive question and comment, both in writing and verbally, issued on the DEIS. Once the final environmental impact statement is prepared and accepted, we then move on to the last step of Seqr, which is the finding statement. The finding statement is where the lead agency sets forth its rationale for deciding which among those alternatives that were studied is the one that produces the least amount of impacts, while balancing those environmental factors and the social factors and the economic factors. And once that finding statement is issued, Seqr is complete. I do want to mention one other thing. There are a lot of resources on Seqr available on the DEC website. This is the Seqr handbook. There was a new edition just released a couple years ago. It's it's super thick, as John was just mentioning, but it's really user-friendly. It's sort of in a question and answer format. So this is a really good go-to resource, but there's flowcharts and lots of fun information and resources available on the DEC website if you're interested in learning more. And that's
Thank you.